Good day, and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we explore patent anatomy. It's been said that the public body of patent literature is one of the great libraries of the world. But what's actually in a patent? What can you learn from reading one? And where do you even find them in the first place? For answers to these critical questions and more, I sat down with Patently Strategic regulars David Cohen, Principal at Cohen Sciences, and Ashley Sloat, President and Director of Patent Strategy here at Aurora. In our discussion, we break down the key anatomy, cut through the terminology, and provide tips on how you can use this information for your competitive advantage. All right, David and Ashley, thanks so much for joining me today. You're welcome. Looking forward to this episode. Patenting can be such an essential part of the early startup years, but it's admittedly a very complex domain. It has a lot of special vocabulary, and all of that can make it seem a little bit less accessible than it was designed to be. And in putting these questions together for the two of you, kind of had an epiphany, and it was that if I had had the answers to these questions much sooner in my own foray into this world, that a lot of things would have made a lot more sense much earlier on. And I was a bit hesitant. We were a bit hesitant calling this one patent anatomy because, I don't know about the two of you, but the only thing I wanted out of my anatomy and physiology class was me. But it really is through the study and the structure of the patents, specifically the applications, and their parts, that you begin to more clearly see, how things come together and how the world of patenting works. That ended up kind of being a nice surprise for me in this one. So before we start diving into the actual application anatomy, I think it makes sense to start a little bit zoomed out with the application itself. Just so everyone's starting from the same place, what is a patent application?
Okay, well, the ultimate goal of a patent application is to have a patent issued, and so the patent application is basically, a letter to the patent office that describes the invention, and at the end recites some claims that the inventor believes that he's entitled to. So that's the short answer. It's a letter to the patent office, and the applicant, the inventor, wants to get a patent, and he or she or they recite claims they believe they're entitled to, and then what ensues, over a protracted period of time, is a conversation between the patent office, an examiner in the patent office, and the applicant, and that process is called prosecution. So that's the short answer. So I'll just go on a bit. I mean, a patent application, you want to get a patent. Well, what's a patent? A patent is basically a deal between the applicant and the United States government, in which, if the patent is issued, then the applicant gets a monopoly for a limited period of time on that invention. And the other half of the bargain is of course the applicant needs to disclose and describe his invention and basically make it available to the public. The purpose of this is to advance the welfare of the country, right? You want the country to have access, as a matter of policy. You want the country to be able to use the technology that's being invented, and that's in the interest of the country. So that's the deal. The government and this is in the Constitution. It's one of the, explicitly there. This is, I believe, from Thomas Jefferson. So the country says, okay, we'll give you a limited monopoly, if and when you tell us all about it. And so there can be a bit of hesitancy there, right? You've invented something clever, you think it's great, and you're being asked to disclose it. So that's all part of the grand bargain.
If memory serves too, that's actually the only time the word right appears in the Constitution, and it's capitalized. So it was seen as
I didn't.
That's rich, given how far the patent system has fallen.
Yeah, it predates the Bill of Rights. It's the only time the word right was used in the Constitution, and it's capitalized. So clearly, clearly the founders saw this as something very significant.
Right. Well, I mean, patents have a history that precedes the United States. I mean, there's systems in Europe which are very similar. Of course, they didn't have a Congress. They had a king, but the basic idea was the same. Awarding a monopoly in order to encourage, invention and technology coming forward. The idea being, if without that protection, then someone else could come along and copy you and take away your market, and the inventor, would be left in the cold. So, yeah, I didn't know about it being capitalized. I mean, it's sort of like, in Word, right? You can bold it, you can underline it, you can give it a color, you can make it italic, so. Anyway, I won't forget. Thank you, Josh. That was. I'll use that again. I didn't know that particular nuance.
Yeah. Welcome.
And I think the other interesting part to note too in this patent application process, or kind of what is a patent application in especially in the startup world where it's more important, it gives companies the right to say patent pending. Now, of course, you don't want to go ahead and share those contents until they are published, unless you have some kind of defined relationship or something with the other group. But it allows you to kind of have that patent pending status, which can kind of be a badge of honor for companies and startups. And so, I think that's really interesting. But again, there is there's a timeline to all of this, right? There's upwards of 18 months of secrecy where it's not published. And then after that, then it becomes published, and then it's published again when it issues, and it will have the final claims at that time, the ones that have been granted as a result of prosecution that David was outlining. So I think that's also kind of important to know, that there is kind of that secrecy period that also kind of gives you an advantage, and that's 18 months from your earliest date. So.
Right. I mean, this is interesting because the standard answer, why get a patent is just what I recited, right? You get the monopoly, and so on, but the timeline is quite protracted, right? It takes forever, and what happens much more quickly is the conversation with an investor or in investors, and I think I was thinking about this. I think the investor discussion is particularly important to startups. The application. I mean, it's almost like an advertisement, right? Okay, here we are. It's a war dance. Look at what we did. You put out a press release, and the point is to raise money, and without that money, you don't go anywhere. You don't go anywhere soon.
I did want to kind of, insert in there too that, these ideas can't live in vacuums early on, especially in terms of talking to investors and trying to solicit, potential very valuable feedback. But a lot of the people that you would talk to at that early stage, especially investors, are, pretty hesitant about signing NDAs given the handcuffs that come with those. And so, seeking out that application, especially a provisional, talk more about that later too, really helps to give you some protection around being able to disclose your idea without risk of, hopefully without mitigating idea theft risk, and also not shooting yourself in the foot around patentability later on up the road. And we talked about public disclosure quite a bit in past episodes. Recommend that folks check those out. All right, so we started kind of diving into this a smidge in the last question, but right after what a patent application is, we should probably address who it's for. So over the course of its life, an application is going to have multiple audiences, all with very different roles to play, and different goals in consuming and interpreting that patent. Who all might look at an application and why?
There's an investor component and there's an examiner component. And those are going to be, each individual is going to be looking at it to a different degree. Investors are probably higher level. What kind of protections is this generally going to afford the company, the inventor, the technology, and the examiner with a much higher level of scrutiny, because they need to assess it for various metrics based on the Patent Office rules and procedures. But then, there's additional layers there, and that's the Patent Trial and Appeal Board. That's important for appeal proceedings through prosecution or even post-grant proceedings. And then there are the court system, district courts, federal circuit, maybe even Supreme Court, so it's in that drafts person part.
There's jurors too. If you're in the court, you're talking.
Yeah,
you're talking to lay people, right?
Right.
That are
so there's like multiple different layers there. So you want to think about your invention from an inverted triangle perspective, right? Broad to narrow, but also in identifying the problems that you're solving and what are those solutions and how do you describe those more generally? How do you describe them more specifically? What are alternatives? What fields can different things be used in? And so it's kind of just thinking about it from all these different angles, from broad to narrow, again and again and again, to help, and same with how you would define terms, which I think we'll probably talk about later, but how you define what certain things mean in the application as well should be with that lens of investors versus examiner versus judges and jurors and courts and PTAB. So there's lots of different readers, and it's not an easy thing to draft it to fit all of those narratives.
Right.
Add to this too, because I think it's important for understanding some things that'll come up in a bit. And with the ultimate goal of the patents, with the government's ultimate goal of the patents being progressing science and useful arts, it seems to me like the ultimate intended audience, obviously the patent office is huge, investors are huge, potentially someday up the road courts and PTAB, but like really the ultimate intended audience is a person skilled in the art looking to build upon the idea. Correct?
I'd say so. Right. I mean, that's what disclosure means. You want the public, you want it to be accessible to the public.
It is important to point out though too that it shouldn't be. I don't want to sound snooty in saying this, but it shouldn't be dumbed down for anybody though, because it still is meant for somebody of skill in the art, right? So I think that's where the inverted triangle comes in, because it should be understandable by people generally in the public, but it really is geared towards somebody of skill in the art. So you don't want to have this a very complex mechanical device or complex software that you read it and you're like, how is this complex? It sounds like a mental process. It sounds like an abstract idea, which is what the patent office would say. So it's that understanding that you want there to be some level of understanding by jurors or lay people or something like that. But you also are still writing for somebody of skill in the art so that they can take it and build upon it.
It blows me away a little bit though, that it is written for someone skilled in the art, but it passes through so many hands along the way who potentially are not, who have a pretty outsized impact on, like the ultimate validity of of that thing. It's kind of crazy, right? That the ultimate audience isn't necessarily the gatekeeper of the thing's long-term validity.
Yeah, I mean, it's sort of impossible to do perfectly because you don't know which way it's going to go. I mean, as a patent writer, you just you do your best, and you hope for the best, and there's lots of things that are unforeseeable. Yeah,
Excellent.
another thing that occurred. I mean, I think about this. In a way, the patent literature is one of the great libraries of the world, right? If you and it's free. I mean, it's really kind of amazing. I mean, there's this huge literature, and once you know how to search, or you have someone searching for you, you can learn everything, right? I mean, and it's free. It's like the Library of Alexandria, right? I mean, it's kind of, I think it's underappreciated. The amount of knowledge that is stored in the collective patent literature. I mean, I include world. I mean, we're sort of focusing on the United States, but every country has its patents. I just wanted to sort of toss that in as a reflective comment and appreciation that you don't really hear.
Yeah,
So,
and actually, to build upon that and to contrast that, David, coming from the academic world myself, where because patents are the cutting edge in theory of technology, and so is academic research, right? Or research in general. But in the academic setting, you submit, I mean, it's different, right? Because in the academic setting, you're submitting your latest and greatest research, whatever, to an academic journal. They're reviewing it kind of like an examiner. And then, but then they, charge you a ton of money, kind of not unlike the patent office, I guess, to publish it. But then it goes behind this paywall that you can't get access to. Very few journals are freely accessible, right? Most of them put their content,
absolutely,
the content that I gave them behind a paywall, which were the point I can't even access it, right? Whereas the patent system, right, you're still paying money, somebody's still reviewing it, but like you said, it's out there and available.
And just to second Ashley's comment, all these academic journals, I mean, they cost millions of dollars, right? And you can get access to them, if you're in the university. But for the general public, all that is very difficult to get. So anyway,
no, it's a great point. It's a great point. Love especially about the being one of the great libraries of the world, and I think that also serves as a wonderful segue to our next question, which is for someone who's never looked at an application at a very high level, what kinds of things can I learn from a patent application?
Well, one thing that I was going to say, which is relatively trivial, but if you look at that application, I mean, there's the standard fields, and you'll see some of them on the front page. There's the inventors. It's their institution or their company. It's the title. It's the abstract. It's a picture. But if you, I mean, frankly, one of the places to start is with the background. Because the background is intended to orient you as to this invention fits within this background. Now you have to keep in mind that this is the inventor's view of the background, so it's not necessarily objective. It's how they want you to see it. But if you're looking for an easy entree, often it helps just to read the background, because you're not going to get challenged. It's going to sort of set you up. And and then you sort of know where it's headed. But the things that we've mentioned all these various fields before. There's the title, there's the abstract, there's there's the pictures. I mean, if you think about it, a patent application is really just two things. It's words and pictures, right? Or words and data, and they should come together and fit, and each, be consistent with each other. The entire point, I mean, leaving aside investors and everything else, the entire point is to support the claims, and the claims are found at the end, and that's, if you're really getting, down into the weeds, you need to look at the claims. They're at the end, and you sort of need to get, you need to surrender to the strange language of claims, and that's, that's the name of the game, is what is being claimed. That's the territory that, if the application is granted and the claims issue, then that's what the inventor has a monopoly on. So, is that sufficient, Josh, or should we drill down on anything more?
I mean, I think that hits on a lot of it. Yeah, the issue date is in there, right? Which that can help. That can help give a clue as to how long the patent could be enforced. Correct.
I mean, there's the filing date, and then there's the issue date. So a patent term is calculated from the earliest non-provisional filing date. So your provisional year is free, and so that's 20 years from that earliest non-provisional filing date. And then the issue date is when the patent actually becomes enforceable. Right now, that doesn't mean that there's some different things where it might be enforceable earlier on. Like if it published with the same claims that it issued with, in theory, some damages could go back to that publication timeframe. But suffice it to say, the issue date, the first date it comes online for enforceability, right? And so those two dates are important for understanding, because then also if you calculate the rough expiration date, if you say it's, January 1st of 2000, it's going to expire, generally speaking, January 1st, 2020, then when it's going to expire. So then when potentially it's not a problem anymore.
Right. So we've got the when of the dates. We've got the who of inventors who are involved, and ownership, which is potentially not necessarily the same thing. Any prior art that was dug up is going to be in there. Drawings, of course. We said it's words and drawings, and then the words. Ultimately that written description, aimed at enabling one in the skilled in the art to be able to. I believe the legal language is reduce the idea to practice without undue experimentation. Is that right?
It's close enough, right? You want to practice. You could just say practice. Practice the invention. Yeah. So do it. It's like the idea recipe, right? Yes. Yeah.
There's more ambiguity in the recipe. Where the recipe says it could be a teaspoon, it could be a cup, but it might preferably be a tablespoon.
A pinch, a pinch of salt, Yeah.
The competitive advantage of ambiguity. Yes.
Right.
All right. So let's flip that last one around then. What kinds of important patent-related details might I not find in an application? Things that could be useful, maybe things I would expect to see that aren't.
Yes, it's true. The patent application or the published patent itself doesn't tell you everything. And for example, if you want to know, if you really want to know, who's involved and who said what and the whole 9 yards, then you simply need to go to another database. And there's something that every patent practitioner uses at least once a day, and that's another patent office database. It's called PAIR. That's an acronym, PAIR, Patent Application Information Retrieval. So that also is free. It it it's less easy to search if you're using. John, we'll mention a few websites, and anyone listening, I mean, you can try to take notes, but if you really want to get the address, you can email Josh, and he'll send you the address. So
I will include
right.
all reference links in the show notes as well, so they'll be right at arm's length.
Okay. Okay. Yeah. Yeah. So there's lots of things that I mean, in a way, the patent office doesn't really care so much about who the assignee is, and and owners of a patent, they're not really bound to tell the patent office, if they've licensed it or sold it. So assignee information, by way of example, is something that is difficult to know, without calling up the inventor or the company and just asking them. That's elusive. Now, one of the other things, okay, the expiration. Yeah, there are paid databases. I mean, I subscribe to a relatively inexpensive database, and you'll get other. You can find out. Are the maintenance. Yeah, maintenance fees. I mean, this is another thing that people don't think about, but you have to pay the patent office to keep your issued application alive. So those are called maintenance fees. Has it expired? You can actually get that on a number of different bases. The current owner, like I said, can be hard to find. Usually, if you really want to know, you probably would need to go to, one of these massive databases like LexisNexis. They probably would be the best source. Has it been invalidated, enforced, licensed, or sold? You could probably find that in one of these massive databases.
I guess if I could synthesize that down, it sort of sounds to me like the application it's frozen in time at time of publication or issuance, and so any
you don't know what happened later, right?
You don't know what happened later. Exactly. So those, has it been kept active? Has it expired? Who currently owns it? Invalidated, enforced licensing? Any of those kinds of post-publication, post-issuance things? Not gonna find it in there.
Right. Yeah. Applications and publications, they're frozen in time. They're true at that moment. They could change the very next day, especially like, assigning who owns it is the thing, which is probably the most elusive. So, yes.
And I guess we just recently used these words, but one point of confusion that we often see, especially among inventors newer to the process, is the difference between a published application and an issued patent. Could either of you speak to this distinction?
Well, like Ashley said, the published. Okay, you can look at it's true. This is a point of confusion, and you sort of need to look, at the upper right-hand corner of the front page, and it'll either say patent number or it'll say patent application number, something like that. It'll tell you, and then. Actually, the quickest visual cue as to whether it's a published application or an issued patent is to look at the number, and the published applications always start with a year. So if the number starts with 2017 / digit, then that's an application. So the only difference between a published. Go ahead.
I think the additional, difference is just, one's fluid and one's static to some degree, right? You can't, in a patent application, you can't change the figures beyond the scope of the original application and the specification, but you can change the claims. In the issued patent, the claims are static, right? They're done. They've gone through the prosecution, gone through examination. So one is still in that bartering conversation process, the publication is, and then the issued is kind of post that process.
So prosecution obviously plays a big part in this, right? So with the published application, you've got the document that the applicant filed. That kind of includes what the applicant wants, but the issued patent is the thing that has really like gone through the machinery of prosecution and has kind of been like whittled down to what the examiner has allowed. Is that correct?
Yes, yeah. The all the figures, all the text of the published application and the patent issued patent are the same. I mean, except for typos and small mistakes that are picked up. It's all the same except for the claims. And the difference is, what you're looking there at is, the aftermath of the argument between the examiner and the applicant. And there can be a degree of compromise, but basically the examiner wins. And what matters at the end of the day, in the formal sense, is the claims as they issue in the granted patent. Yeah, I mean the purpose. I mean part of the reason that the application is published at all. I mean before it issues. I mean it, in a way this harmonizes the U.S. with the rest of the world, but also basically serves the function, the constitutional purpose, which is to disclose. So, I mean that's just sort of a policy statement. It is possible to not have your app to ask the patent office to not publish the application, and if you do that, then you're restricted to U.S. because the rest of the world demands publication, demands disclosure right off the bat. So you can avoid that in the U.S., but what you lose are your worldwide application rights.
I think that's worth
I mean,
underscoring too. We really like to flash, danger signs wherever they exist, especially things that might not seem intuitive. And I think this is one of those places where, just because you submit a patent application doesn't mean that you're going to get an issued patent. But without a non-publication request, even if that patent doesn't issue, your disclosure is going to become a published application, even though it is not a granted patent. So even though you don't get the protection, the disclosure still happens without that request. So that's definitely like a sharp corner to be aware of.
Right.
All right. So there are different types of patent applications for different scenarios. Could you briefly describe the types of applications and when each would apply?
Well, in the U.S., there's three basic types of applications. There's a utility application, there are design patent applications, and there are plant patent applications. So, so the different. Let's compare and contrast. So, utility versus design. A utility patent. I mean, this when people talk casually about patents, they are almost always talking about utility patents, and the word utility suggests that these are useful inventions, and that might sound trivial, but it is one of the requirements. And in compared to design patents are for decorative purposes without claiming any particular use. For example, tire treads. I mean, if you take a class in patents and they talk about design patents, tire treads are a good example, right? I mean, tire treads they all look a little different. There's this zag and that zag. These are important for certain companies because they want their product to be recognized by its design. And plant patents. Well, plant. I mean, this is a very specialized area, but it's very important for seed companies and commercial roses and peaches and stuff like that. But like I said, utility patents are the main event for most people. And there actually is another wrinkle. There's something like a baby utility. The provisional often looks very much like a regular application, but it's not prosecuted, and it just stays in the patent office as a placeholder. It records the fact that you have your invention in hand at the time of the filing of the provisional. The provisional was something that was put in place some years ago in order to harmonize the U.S. with every other country in the world, because there were various differences regarding disclosure. So it's very common now. In fact, there's practically no reason not to file a provisional. A provisional, the cost of filing is basically zero or $130 or something, and it needs to be replaced. That's the verb that's used. It needs to be replaced by a regular application within a year. So the purpose of a provisional is to avoid some of the hassle and some of the cost of filing a regular application and kicking the cost down the road. And it gives you a chance to think about whether or not you really want to pursue it or not, or if you want to add something, it's possible to add. You wouldn't get credit for the the priority date of the provisional, but I can tell you that every regular application I've filed has been, it starts with a provisional. It's temporary 1-year placeholder.
That's very helpful. And I never appreciated the where the utility name came from. It makes a lot of sense. The other thing that always threw me too was that the primary application is prefaced with a negative. So, you start with provisional, but the main event is the non-provisional. And so where you want to go is led with a negative. And so that always kind of tripped me up a little bit in understanding.
I didn't like, people started calling it non-provisional. I'm not sure who started. I just say regular because I also don't like the non-provisional. I always just call it regular application.
Yeah.
It's confusing.
It really is. So, like you said, design and plant patents are definitely their own beast, and so we'll kind of save them probably for another episode. And for the rest of our conversation, we're going to focus largely on provisional and utility patents. So, without going into deep specifics on the sections, which we'll cover shortly, how much do provisional and non-provisional applications differ in form? When we talk about the sections, of an application coming up, do they both apply pretty equally?
Well, the thing about provisionals is that there's no they don't enforce the format. Basically, a provisional doesn't necessarily look like a regular application, but when provisionals first started, when they were first came on the scene, I think in 1996, they were sort of abused. That people would take a picture of the whiteboard where they scribbled out their invention and file that, right? And that didn't work out so well, because you can't really claim priority to a provisional unless what you're talking about is in the provisional. So the quick and dirty provisional had its day, and I think scarcely exists anymore, just because it wasn't working out very well. So in general, I mean, the trend in law firms, and I adhere to this too, is that you try to make the provisional look as much like the regular application as possible. You might as well make your provisional look as much like the regular application as possible, because you're covering more ground, and it forces you to think more deeply. And in general, if the provisional, it looks a lot like the regular, it means that you've put your thought into it, and it's more defensible. And if you want to show it to an investor, for example, it looks more real. So the answer is how the difference in how they look. It's just hard to say. There's no rule for the format of a provisional. You can send in whatever you want, and chickens may come home to roost. But anyway, my practice, and I'm sure Ashley's practice and most people's practice, is to make the provisional look like a regular application, for the reasons I mentioned. So
that makes a lot of sense. We talk a lot about kind of cocktail napkin fidelity, being required for provisional, but you definitely you don't want to take that too far, like you said, and just send in a picture of the
you don't want to take it. Yeah, don't take the
napkin
napkin thing literally. That's just a myth.
Right.
Yeah.
Yeah.
Yeah. Don't do that. Yeah.
Good. Like you said, and a good forcing function. So now onto the actual anatomical breakdown, part we've all been waiting for here. As I understand it, the four main parts of a patent application are one, the front or cover pages, two, the drawings, three, the specification, and four, the claims. Can you walk me through the purpose of each, what we might find in each, and highlight any other important subsections? Big question.
I sort of divide it up between words and pictures, right? I mean, you want the words and the pictures to fit together. They need to be consistent. And having said that, I mean, one of the purposes of figures, or data. I'm talking about figures mainly. I mean, you can always have data also, but they say a picture's worth 1,000 words, and so it depends on the subject matter, right? But for many types of applications, the figures can basically function as a storyboard. You should be able to, march. If you were going to explain your invention to someone else, you should be able to just march through the figures. And often, figure one or one of the early figures is sort of a big picture. So figures vary in terms of their level of detail. There's you've all seen the picture. Here's our device. Here's the cloud. Here's the server. Here's sort of big picture cartoon of the whole thing, and then you slice it up into smaller pieces, and here's a close up of this, and here it is from the top, and here it is from the bottom, and so on. So so the big pieces, like we've mentioned, there's the text, and the various sections are the abstract and the claims and the rest of the written description, and so I mean, it's helpful to think of how a patent application gets written. And most people, and the way I write, is that basically you start with the claims, right? Blank piece of paper, and you don't. I mean, you can start with the title, but you start with the claims because that it's like in an academic paper. Things can change, but in general, if you're writing an academic paper, you sort of know your conclusion, right? And you write the paper with the intention of supporting the conclusion. So in a patent application, where you want to end up with are claims, and so that's where you start. You start at the end, and then from the claims, a couple other things follow. The abstract should reflect the claims. It often the abstract is just a narrative version of the first independent claim. The summary, which comes along, after the abstract. Well, depending on it comes at the end of the application, but it's also on the front page. But the summary in general is a narrative version of the claims. So claims are written in kind of an arcane style, and for readability and general consumption, the claims can be converted into more conventional narrative. So that's what the summary is. And then there's also a section called brief description of the figures, or brief description of the drawings, and those are basically like figure legends. Figure 1 shows this and this and this. Usually the paragraphs in the brief description of the drawings are just one sentence, and so if you're reading the patent application, it's useful. Okay, here's a figure. You want to be also looking at the brief description, and that's how to understand it. And then in general, the body of it's called the detailed description. Usually this makes up the bulk of the application, and that's a narrative. I mean, there's no particular order, but in general and for readability, the written description follows the order of the figures. So figure 1, A, B, C show this and this and this, and you describe it, and there's part numbers, and you just sort of march through the application, explaining the figures and how it all fits together, connecting one figure to the next. And there's the back. I mentioned this before, right? Some people really don't take the background seriously. But if the patent application is written to be informative and respectful of the reader, the background is not a bad place to start. It tells you, it gives you the context, and into that the invention should fit. Okay, there's another word. It's called specification. Specification actually is the application in its entirety. All the words, all the pictures. That's the specification. Yeah. Does that sort of cover the basics? It's sort of.
I think so. Yeah, and we're kind of logically separating specification from claims a little bit in our discussion, mainly because there are a handful of fields that you talked about, like the title and field of invention, and background and summary, and the description of drawings, the abstract, stuff like that a lot of those things in aggregate sort of provide context for interpreting the claims section. So there's some utility, I think, in grouping those things together a little bit, and helping to set the reader up for understanding the claims. And to the best of my understanding, because this was actually a little bit of a surprise to me, that in terms of establishing that context, because patents are describing new things, they actually provide some flexibility before you get into the claims on how your terms are defined.
Yeah, I mean that's part of the story. I mean, if you want to use a word in a particular way, then you can. I mean, if you're using it in an unusual way, then you really need to explain it. Or occasionally there will be a patent application with a word you don't even know, right? And So there is that freedom. Lexicographer mean you can write your own words. The only I mean, and it won't work. I mean, you can't call a fork a spoon, for example. You can't you
It's
you
good
can't
distinction.
use you can't use an entirely wrong word. That doesn't fly. In general, the patent application requires not re- it relies on the plain meaning of the word, especially to someone in the art. I mean, you don't have to define everything if it's already well understood in the art, and so you don't need to define every technical word. And in fact, there are some people who sort of purposefully don't define, a word they think is well known, because the concern is, well, one, you're taking up extra space, and the other is, maybe there's an exception. So if you define it and then you want to use it in a different way, then you're sort of stuck with what you have. But yeah, yeah. The application is, it's a look into the mind of the inventor or the patent writer, and sometimes, a new word or a word used in a slightly different way, or a word used, in a way that helps the invention to make sense. Then yeah, you're your own lexicographer. Yeah, I mean, it's kind of nice, right? I mean, it's a good thing.
If you're trying to define things that are novel, non-obvious, effectively new, sometimes that comes with some new vocabulary.
Right. Or you can take an existing word and use it to your own particular ends, right? I mean, a lot of words, they have different meanings, and I mean, you could have a little device that, for whatever reason, has a part that looks like a chimney, right? Well, it's actually not a chimney. There's no there's no smoke coming out of it or anything, but it looks like a chimney. So then you can call it a chimney, right? I mean, and so yeah, yeah. There's a lot of flexibility, but you just have to make sure you're being clear about what you're talking about.
Sure, sure. So let's talk a little bit more about claims. I think it's worth going a little bit deeper on a handful of things, just because it really is it's the heart of it comes at the end, right? But it really, you talk about writing it first. It's really it's the heart of the application. Um, I heard you once use a great metaphor about those with the Old West. Would you mind sharing that? 'Cause especially as we kind of as we break down some of this vocabulary, like, why are some of these words used? Um, I think sometimes that history and sometimes those metaphors can be helpful.
Yeah, right. Yeah, yeah. I mean, the metaphor I used, or the analogy, everyone has seen a Western, and there's the miner out there in the mountains digging a hole, and he strikes it rich, and he drops his spade in his bucket, and he runs into the claims office, right? It's in town. There's a guy behind the desk, and what he wants to do is lay claim to that mine, which means that he can work it, and no one else can. And the reason he has that privilege is because he discovered it. So you go to the claims office, you would draw a map. It's between the lake and the mountains and the prairie, and there's this landmark, and so on. And then you become more specific, right? You draw a square, you draw a circle on the map around what you're claiming. So what you have there is, you have the particulars of the mine, and you put it in a context. So in a way, it's the same way with the patent. I mean, in a way, the entire written description, it's talking about your device, or whatever it is you're inventing, and you put it in a context. It can be used this way, or it can be used that way, and so on and so on. But but you need to become more specific and claim the boundaries, the boundaries of what you believe is your invention. So, I mean, the Old West, the mine, I mean, to me, it works extremely well. That's intuitive, and it sort of transfers pretty directly into, the role of the claims in the application. So,
yeah, clear delineation of the boundaries, right? I think it's a great visual, really great visual.
Yeah. So, I mean, the main purpose of the claim is to be able to exclude others, right? And so the question of does the claim exclude, that other guy and what he's doing, right? You don't want people intruding on, you don't want them infringing your property. In this case, your property is intangible. It's a patent application. I mean, it's a patent. So what it comes down to is, let's say, the inventor, the applicant, the company says, hey, that product, that looks a lot like ours, and we think you're infringing. Well, so the question comes down to the independent claim, and we can talk about independent and dependent in a second, but let's just call it the claim. And so, here's an example of a claim. I claim a gadget that includes piece A, piece B, and piece C. A gadget including A, B, and C. And so if you look at the product that you think is infringing, you look at it and you ask the question: does that device have everything that I've just claimed? Does it have A? Does it have B? Does it have a C? Does it fit together the same way? If the other product has all of those elements, then it looks like it's infringing. It's that simple. It doesn't matter. In this instance, it doesn't matter if the device also has D, right? The inventor says, it's true it has A, B, and C, but it also has D. Well, I mean, that's great. Then you should apply for a patent application for A, B, C, and D. But the fact remains it has A, B, and C. So that's sort of how the claims are used in guarding your monopoly and exercising your right to exclude. Going back to one of the things I first mentioned, you don't really have the right. Patent application really doesn't. Sorry, a patent does give you the right to practice your invention, but it gives you the right to exclude others from what you have claimed. So, I mean, that's a nuance that's difficult to grasp, but that's the deal with claims.
One thing I want to go back to a little bit, because it's still something, it's a point of confusion in my mind. So I suspect that it could be the same for some folks in the audience. But you were talking a little bit about infringement with claims. I'm sure this is a huge topic that could be probably many episodes of its own. But I guess the thing that's not super clear to me is, if you write a claim and it claims things A, B, and C, what does constitute infringement? Does somebody have to infringe upon A, B, and C, or can they just infringe on some portion of those? At what point can I say someone is in fact infringing upon my claims?
If someone is infringing on your claims, that means that you believe that they are practicing A, B, and C. They're doing the entirety of the independent claim. everything. That's the deal.
Interesting. So if someone were just to take a look at my patent and piecemeal out just A and B on the path to doing something else, I wouldn't have very strong grounds for an infringement suit at that point.
If they're only doing A and B, they're not doing C, then they're not infringing. That's true. That's the answer.
Interesting. Okay. I didn't know that.
Yeah. This is why there's so much writing on the claims, particularly. I need to explain the difference. I keep saying independent claim, and that's in contrast to dependent claims. But 90% of the intellectual exercise is writing the claims, and it's because you're trying to foresee, these eventualities, right? You're trying to write the claim so as to capture as many possible infringers as you can. So just wanted to make the point. I mean, the writing the claims is the main intellectual effort of writing a patent application, and inventors, once inventors sort of catch on, they begin to think in terms of claims also. So, just as a central intellectual organizing practical principle, most of the focus is on the claims. So let me explain something else, because I mentioned this briefly. There's independent claims and there's dependent claims. So an independent claim almost always starts with an indefinite article, a, or an, a gadget having. So it's not really referring to some specific, individual gadget. It's talking about a general gadget. So you got your gadget, with A, B, and C. That's what you're claiming as your independent claim. But that's not really the end, because it's true. I mean, your gadget might also include D, right? But you don't regard D as being really that essential to the invention. So you could have a dependent claim where you would say, the gadget. So notice I've switched from the independent claim was A, dependent claim 2, the gadget of claim 1, further including D. So what's required in your invention and what you would be looking for as an infringer would be all the elements of the independent claim. The dependent claims sort of recite options. They're not necessarily a part of your invention. At least they're not part of the independent claim. And an infringing product wouldn't, as long as it had A, B, and C, it would be infringing. Trying to summarize, the independent claim is the very bare bones of your invention, and it distinguishes from the prior art. It's new, it's different, and here's the basic elements. It can also include, these optional elements, and those, come on as dependent claims. So typically, a conventional patent application, you might have, one independent claim and 20 dependent claims. The dependent claims all follow from the independent claim. This is a lot. Yeah, this is a lot to absorb.
It is, but David, that was such a great explanation, and I'm glad that we talked about independent, dependent claims after we talked about infringement, because that's actually the clearest explanation I've heard. It's the clearest it's ever been, in my head. And I hope too that folks listening appreciate, that you think about you think about the word application, and the word form comes to mind, and when the word form comes to mind, you think about like just kind of monotonous, tedious data entry, and there's so much art and so much strategy that goes into this at every step along the way. And so anyway,
yeah,
I don't again, before I kind of got into this world, I don't think I fully appreciated that. But there's like so much art, so much strategy, so much nuance, and those little decisions that are made now can have huge impacts on the long term viability of this patent in terms of your ability to defend your rights in terms of infringement, and your ability to retain your rights if ever faced with invalidation, and all these things flow into that.
I'm glad it was helpful. I mean, I can tell you, the next time you look at a patent application or a patent, you'll feel more at home.
Right. Exactly. You got your patent.
You will.
Patent utility belt now. So we hinted at some of this a little bit earlier, but I just want to make sure, because I like folks to leave with really strong useful takeaways. So we've talked a lot about what you can find in a patent. So where all, because it's this public resource, right? So where all can I find patents and get access to this wealth of information?
I think that Google Patents is the best place to start. It's free. There's two levels to the site. One is just I forget it. Just like the conventional Google search bar. You put in whatever keywords you want there. There's an advanced form of it. It'll be there on the page. Another link. Go to the advanced, and it has different fields. In a way, this is where knowing the anatomy of the patent becomes helpful, because the patent is built up section by section, and if you're looking at a search site, they're called fields. So, for example, there's a field for the abstract, and so you can search for your keyword in abstracts, or you could be looking for a company, right? What is the Acme Plumbing Company? What have they invented recently? So then you can search for the assignee, or maybe an inventor. So then you can search on the inventor name. That's how you find stuff. So I mean, there is a cost to searching, right? Because Google, as good as it is, it is limited compared to these larger subscription databases, which give you more fields and more detail and on and on. So, I mean, the patents are free, and you get the PDF, but actually finding them takes a little bit of work. But yeah, it's paid databases, and it's Google, and there may be one or two other search sites.
And then, of course, there's the searching directly with the USPTO, right? USPTO.gov, and then access to public pair as well. I think you need to have the serial number at that point before you can dig into public pair. So you have to kind of use one of the searches first to get to that point.
Yeah, correct. Yeah, for pair you need the serial number or the publication number. I mean, it's just you sort of need to know it already to get the full dossier, from pair. They divide it up, by the way, between issued patents and patent applications. So that's, I mean, this sort of goes back to what I was saying. I mean, it's such a resource. I mean, it's free. It's like the Library of Alexandria, but you sort of need how to work it.
Yep, for sure. And like you said too, of course, you can use practitioners and search firms like ours too for results, access to more databases, and some expert analysis sprinkled on top of that. So like we mentioned, some of this stuff is behind paywalls and things. So just kind of depends on how deep you want to go, but there are always more options. All right, I think we got everything. We got everything and then some. Unless either of you can think of anything else that I didn't ask, that seems like a pretty solid primer to me on patent anatomy. Thank you both so much for your time. I think this context is going to be incredibly valuable, especially for folks newer to the process. And selfishly, I know I got a lot out of it.
Okay. Yeah. Yeah, it's good. I mean, even for me and for Ashley, it's good to, go back to basics, right? Now and then, and just, just, read the good book. What? Let's talk about Let's talk about the Constitution, right? There's the word right, yeah, and it's capitalized. I mean, so yeah, it's a good exercise.
The patent gospel according to David and Ashley.
Yeah.
Yeah, right. Yeah,
I
the
like
gospel.
it.
That's the word. Yeah, right.
Well, perfect. Well, take care, everybody.
All right, thanks.
Oh, thank you too. Yeah.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at auroropatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@auroropatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.